Hi guys, welcome back to my channel. For those of you who are just tuning in, I'm Deborah and you are watching Ask Deborah. So today I decided that I'm going to talk to you about something that's really relevant at the moment. I had a few topics that I had in mind, but I thought this is something that actually needs to be addressed. Today we're going to be talking about the Covid-19 rules and separated families. Now, there will be a lot of you at the moment who are going through different circumstances at home, be that you're going through a divorce, some sort of a separation, or that you actually had a separation prior to the lockdown restrictions and you want to know about contact with your children. During the first lockdown, we know that the rules were somewhat ambiguous in that we didn't know what we could or could not do. Thankfully, the government have since expressed an exception in that children under the ages of 18 can move between households when it comes to contact. Your children can come and spend some time with you as long as it's safe to do so. So really the government are expecting for mums and dads to come to some sort of an amicable agreement and arrangement between themselves, understanding what's safe and what isn't. And really, you shouldn't be prohibiting contact between a child and a non-resident parent simply because you have a dispute. Where parents are in situations where their ex-partner are prohibiting contact, there are things that you can do and the courts are still open. You can apply to the court for a Section 8 order known as a child arrangements order. And this is essentially asking the court to decide how much time you should be able to spend with your child. Now, by no means is it an easy or quick fix solution, and really the courts would hope that parents can come to some level of agreement to decide amongst themselves as to what's best for the child. But where that's not possible, the courts are willing and ready to get involved. An application essentially involves the completion of a C100 application, which is sent to the court for a fee of £215. The application involves writing a brief summary of what's happening, details of the resident parent and details of the non-resident parent, which is usually the applicant. Now, it can take some time for a hearing to actually be listed before the courts, and during this period it can be really traumatic for both the non-resident parent and the child if they've gone from having contact to suddenly not having any whatsoever. But rest assured, it will be heard. Now, usually what tends to happen is that the case will be listed for something called a first dispute resolution hearing, and that's when both the applicant and respondent, who's the other person or other party, get to present their case to a judge as to why the non-resident parent should or should not have contact. Now, bear in mind, it's not as simple to be able to say we've had a breakdown in relationship or communication and this child is no longer able to see their non-resident parent. It's not as simple as that. The court will take into consideration something called the welfare principle, and that essentially says that the child's welfare is first and foremost paramount above anything else. So where it's safe to do so, that child should really be able to see the other parent. And I'm going to generalize here and use that as the father, because 9 times out of 10, the resident parent is the mother and the non-resident parent is the father, for whatever reason that may be, although I appreciate that it can work both ways. It's important to understand that these cases are not cheap and neither are they swift. An application fee of £215 is just the starting. Legal fees tend to be rocket high and your average person just can't afford to spend thousands of pounds in lengthy and emotional court battles. Here's where I come in. I can support you in the capacity of being a litigant in person. That essentially means that you represent yourself. I can help you with filling out the application form, sending it off to the court and responding to the court in whichever way is deemed necessary. Now, usually the applicant will be required to submit something called a position statement, a case summary and a draft order, essentially making up a bundle. Now, there's a way in which the courts like to see this presented, and most people don't really understand how this should be put forward. Of course, I can help you with that also. Presenting this to the court and giving you the best possible argument as to why you should be able to see your child. I'll be honest with you, it's not as straightforward as just sending in a form and seeing what goes. You have to take into consideration what the other parent is going to say. And sometimes there are accusations of domestic violence, abuse, and so on and so forth. And sometimes these are also directed to the children also. And the courts will take these things into consideration. At times, CAFCAS, which are the Children and Families Court Advisory Support Service, will be asked to get involved, especially where there are situations of alleged domestic violence towards the parent or some form of abuse towards the child. Now, these situations can be lengthy and they can also be emotional, especially when you just want contact with your child. As a Mackenzie friend, I can support you not only with the required documents, but also attend the court with you, providing you the information, advice and guidance that you need on the day. I won't be able to speak for you unless permitted by the judge themselves, but I can prompt you to various parts of your bundle to remind you of questions that you should be asking and things that you should be pointing out. In a nutshell, the government have relaxed the COVID-19 rules in relation to children under 18 in separated families, meaning they can move from household to the other household despite the Tier 4 restriction. Residential parents should not be withholding contact unless they have a really good reason to do so. That includes the child or anyone within that household or the household that they potentially are going to has shown symptoms of the coronavirus, or that there are domestic reasons as to why that child will be unsafe to go to the non-residential parent. Where the residential parent is withholding contact and you feel that there isn't anything else that you can do in terms of getting through to them, you can make an application to the court for a child arrangements order. It's worth bearing in mind that these can be costly, time-consuming and also emotionally draining. And where possible, it is always advisable that parents try and work things out amongst themselves. Should you need to make an application to the court and don't have the financial means to do so via a solicitor, you can obtain a support from a Mackenzie friend such as myself who can do all the paperwork and support for you. Okay guys, so I hope that this has been beneficial and also somewhat reassuring for you. I hope that you're staying safe and that you've been able to see your loved ones as much as you possibly can. Don't forget to subscribe, like, share, leave a comment, and of course hit the bell button for more alerts on new videos. See you soon.